move position. So hello, everyone. I'm just going to wait a minute for everyone else to join the webinar and then we'll get started. Great. Okay, let's start. So first of all, welcome to our third privacy question time from the DPN. It feels like 5 minutes since we did the first one on the Wellington ship back in the days when we could all meet up together. My name is Julia Porter. I'm a partner at the Data Protection Network and also one of the founding board directors when it was launched in 2014. So just a bit about me. My background is actually mainly media and marketing. I spent a large part of my career in advertising and then in media organisations, including ITV and Guardian News and Media. And then I've come to data protection in the last 10 years and was the chair of the Data and Marketing Association and have been involved with the DPN for quite some time. So first of all, I'd like to welcome you to this webinar. It's sponsored by our friends at OneTrust and is entitled Privacy Question Time. It works in quite a similar way to the BBC Question Time. We ask people to submit questions and then we attempt to answer them. Thank you all for joining us. We're delighted that you're with us. I think it's going to be a really interesting and insightful hour. We've got some brilliant guests on our panel today. You may ask questions of the panel through the chat button, and Simon has already left a message there, but I will show you how to pose questions as well. Quite a number of you have submitted questions in advance, and we plan to cover those as extensively as we can. So we are recording this session, so it'll be available for you to view again if you wish, and you should receive a link to that recording by email about this time tomorrow. The other thing to confirm is that the opinions that we express today are those of the individuals on the panel, not necessarily the opinions of the companies they represent. So the panel are on the screen now, and we'll be introducing everyone in a moment. But first of all, Simon, if we can just load up the slides, then I just want to tell you a tiny bit about DPN. Sorry, guys. I have to go back to the beginning. Bit of an oversight on our part. Right, okay, the DPN then. So the heart of our work is providing realistic support and advice. We really pride ourselves on being down to earth, making data protection relevant, interesting and doable. We want to be able to provide pragmatic solutions for our clients. So we're a thought leadership network, data protection consultancy. We help clients both large and small with data and privacy matters, both in the private sector as well as not-for-profit. We publish a wide range of useful articles, and for anyone who's interested, I'd encourage you to go to the DPN website where we have a variety of articles. We've just done one about cookies. We did a number about the government data reforms, so it gives you a chance to see a summary of what's being written rather than read the whole thing yourselves. We also provide training workshops for teams who handle personal data, and they're always practical and engaging sessions, and we try to use relevant examples as much as possible to bring it to life. And of course, we run events like today. So we've got a number of events coming up in the early part of next year that's also supported by OneTrust. So I'm going to pass you over now to Robert, who is just going to give us a little bit of information about our sponsor, OneTrust, and about the panel.
Thank you, Julia, and thank you for asking me to chair or moderate the privacy question time today. And thank you to OneTrust, who, as you can see, are the #1 fastest growing and most widely used technology platform to help with trust, compliance, governance, etc. With more than 7,500 customers, including half of the Fortune 500. As we know, OneTrust have built programs to comply with CCPA and the GDPR and the other emerging laws around the world, and are backed by a number of patents and a lot of other intellectual property and know-how. What I wanted to do now is look at the panel. So if we could move to the next slide. Very briefly, I'm a senior counsel and a notary public with Bristow's law firm in the London office. I've been doing data protection since 1983. And apart from advising clients, I'm also on the United Nations expert group of governance of data and artificial intelligence, and I chair the advisory board of the DPN. Julia's already kindly introduced herself. So Yasmeen, can I pass to you just to say a few words, please?
Yep, of course. I'm the Group Data Protection Officer for Informa Group. Informa is a B2B company, so we run something like 800 events a year. We have many, many media sites. We work very heavily in the B2B sector. In data protection, I've been working in data protection now, actually nearly 10 years. In Informa for 4 years, but prior to that, I was part of the BMW Group data protection team. I helped build all of that up. In addition to data protection, my background is IT risk as well, project management, and so forth. So it's sort of good. I have a nice blend of technical skills as well that I bring into the role as well.
Fabulous, thank you. And now, Roland, please introduce yourself.
Yes, good afternoon, everyone. My name is Roland Verhaaf. I'm the Group DPO at the Phoenix Group, which for those of you who don't know, the Phoenix Group is the UK's largest long-term savings and retirement business. We also have businesses in Ireland, Germany, and Austria. So obviously have that side of the business, which is interesting, and we can talk about that context later on today in some of the questions that we have. Also non-executive director at the Data Lab in Scotland. That's a think tank group in Scotland, joined by a number of universities and in conjunction with the Scottish Government, looking at data science in Scotland. Been in data protection for a number of years. My background is started in financial services within security. It's kind of like Yasmeen, IT security, InfoSec background, and came into data protection, I guess, about 3 years before GDPR enforcement. So kind of seen the journey of where we are today, and looking forward to discussing where we're going with some of the government's proposals.
Great, thank you. And then finally, last but not least, Alexis from our sponsor, OneTrust. Alexis.
Thanks, Robert. Hi, everyone. Lovely to be with you today. I'm super excited to be part of this panel. As Julia was saying, there's quite a few interesting questions that have come up from everybody pre-event, which we're looking forward to discussing. So my name is Alexis Kateifides. I am one of our counsels here at OneTrust. And that means a couple of things. Mostly I spend a lot of my time keeping track of changing regulatory developments, how laws and frameworks are coming out, and assessing the impact on our own compliance program and looking to put them into practice, whatever operational changes we might need to make, but also assessing the impact for our customers as well. We're a little bit unique as a privacy team. We work quite closely with our product team, which is quite cool. Get to see a lot of the tech and have a lot of input into the products and services that we are building to try and assist customers with their compliance programs. And obviously we use our own tools and software for our privacy program. So we're looking at trying to make it as easy for our customers as well. So yeah, I've been in the space same as Yasmeen, probably about 10 years, legal background, but really enjoying where I am at the moment with OneTrust and trying to find creative ways to legal problems as they come up.
Okay, thank you. And Julia, back to you.
Thank you, Robert. So before we get started, I just want to announce the launch of this year's Rosary Smith Award for Responsible Marketing. We actually launched this for the first time in 2019, had an enforced break last year because of COVID, but we're back again this year. So Rosary Smith was a doyen of the direct marketing industry and sadly passed away in 2019. This award is to recognise a contribution by an individual and organisation towards responsible marketing. What we mean by that is largely, creating a culture of openness and transparency with customers, so that they feel like they can trust that organisation's use of personal data. So just in terms of the details here, the award entry launches today. We have details on our website about how to enter. The closing date is not until January, so you've got plenty of time to think about who you can nominate. So you can either nominate yourself or nominate a colleague in your team who you think have done something particularly brilliant in the line of duty. I've just noticed actually there's a typo here. It should be 23rd of January 2022, not 2021. Judging will take place in February next year, and then the award will be made at the Data and Marketing Association Data Conference, which will be held in London probably in March next year. And winner will be participating, finalists will be participating in a panel, which hopefully will be chaired by Robert. And so we'll get an opportunity to talk about their efforts. And as you can see here, here's the link to the launch website page. So just in terms of questions, if you want to submit a question, and we love getting questions from you, hopefully not too tricky. So you'll see on the right-hand side of your screen, there's the chat area. Make sure you're in Q&A mode. If not, press the question mark. Type the name of your business or sector followed by your question. Your name appears automatically because that'll be the person who registered, and then click submit. And then Phil and Simon will be collating any new questions and feeding them through to Robert. So hopefully the intention is to cover as many as we possibly can in the next 45 minutes to an hour. So you won't be entirely surprised to hear that an awful lot of our questions are related to the UK data reform proposals. So here's a quick reminder of what they covered. We've actually written a handy primer on this, Phil did, which gives you a very good summary of what the issues are. And we've also run a survey with our readers and followers to see what people's feedback was to these reform proposals. So we're going to run a couple of polls now. The first poll we'd like to hear your answers to, Simon, thank you, is: are you broadly in favour of the data regime reform changes which are outlined in the consultation paper? And there's three possible answers: yes, no, or not sure. And you should be able to click on the poll any second now. So interesting response. Oh, no, it's moving around a little bit. Oh, quite even actually. That's not sure is winning. Excellent. That's really interesting, actually. Thank you. And then I've got a second poll here. So in our survey, there was quite a lot of polarity around people's views, actually. And so we had four subjects that particularly exercised people. So we've picked those four topics. And what we want to know is, of these four topics, which are the ones that worry you most? And the four we picked were removing mandatory requirements from the DPO, for the DPO, removing mandatory requirements for a DPIA, permitting certain automated decision-making without human intervention, and removing mandatory requirements to carry out a ROPA. So out of those four, pick the one that you think gives you greatest concern. again, interesting. I think with the AI one in particular, it's really hard to tell what's going to happen in the future anyway. Okay, so fairly evenly split. So I think AI and DPOs have the slight lead. No one seems too concerned about records of processing activity, or maybe that's just because it's a difficult and thorny job to complete. Simon, let's move back to the slides then, and I'll show you what our survey said. So the first question, are you broadly in favour? In fact, on our survey, 46% said they were broadly in favour, whereas I think today there were more people who are not sure. I mean, the fact is, I think all of us are we feel it's a bit of a curate's egg. There's some really good bits, and then there's some bits that really worry us. And then the second point was which proposals attract the most positive responses. So requiring organisations to implement a privacy programme, data breach notification threshold changes was popular. I think everyone believes we've over-reported. Amending the thresholds for vexatious DSARs, again, very popular. And creating a limited list of legitimate interests, again, very popular, because I think there's potentially a lot of duplication in the work that's carried out. And then in terms of the least popular, interestingly, removing the DPOs was the most unpopular idea. I have to say, though, this was a bit like turkeys voting for Christmas, in that most of the people we asked probably were DPOs. The DPIA is the second one, and then the AI one was third. So there's a little bit of information there for you to kind of warm up your questions. I'm now going to pass you back to Robert, who will start the debate.
Yes, thank you very much, Julia. And if we can just move on to the next slide, please. And while we do that, again, just to confirm that any opinions given by us on the panel are our own and not those of our organisations. Okay, we've got a lot of questions, and we've categorised the ones that we've already received into the UK data reform, PECA, international data transfers, transparency, privacy notices, DPIAs, the WhatsApp fine, and issues around EU representative. Now, I'm hoping that more questions will come in as we go through the next 45 minutes, but I think we've got a lot to cover. So I'm just going to go straight into the UK data reform. I'm going to start with Yasmeen, if you don't mind, and then I'll turn to Roland. What, in your view, are the advantages of the UK proposed divergence from GDPR, and you personally as an individual, and you personally for the business?
Yeah, sure. I mean, I think I'm trying to put this in context, because at the end of the day, even with GDPR being a European legislation, every country is allowed to bring in additional regulation. So it's never that GDPR was going to be a pan-European one-size-fits-all. We were always going to have some deviation. So in one sense, the UK reform that they're proposing, for me, kind of represents what does the UK really want in terms of data protection. So I think I'm trying to think of it in that context. It gives some advantages. I think they are giving an indication they want to be very commercial about how companies are organized and what is required of us as well. And even on this panel, if you think about it, I come from a highly commercial event company. So to sort of expect a company like ourselves to operate with the same black and white rules that Roland's company does, it's not really, I think, very proportionate. And so for me, the UK data reform kind of represents that idea that we need to follow the principles. And I think that's important, but also it gives us some flexibility on how we actually apply it to our organization. So I think for me, there are some advantages to be seen out of the reform as well. So that's my personal opinion. from a company perspective, we haven't really fully analysed the situation, but I suspect that there will be things that we say, actually, that's actually advantageous of us because we run sort of 60 to 70 events in the UK, and it may actually facilitate our operations in the UK and make it easier for us to run. So I have to take account into that when engaging with my business stakeholders.
Okay, and Roland, what's your view?
Yeah, so I think I share Yasmeen's thoughts around, at the end of the day, by the time GDPR finally came into enforcement in 2018, it was in itself already, been written down for a number of years. And I think everyone, even within Europe, have been complaining about the fact that actually maintaining pace with the changes in digital and data means that actually, we need to have the opportunities to revisit the legislation in a more kind of agile and frequent fashion without creating vagueness and there's a principle of harmonization that obviously the EU still wants to deliver as well. I think it's a great opportunity for us to do that in the UK post-Brexit, to have a look at what works, what doesn't, and there are from having kind of done a quick pass over the proposals, there are definitely areas that have been let's say bugbears for a number of years, just things that just aren't working. I think just to set into context, obviously we're a large financial services organization. We're quite used to being heavily regulated on a number of fronts, so we are appropriately resourced to deal with that. So I do recognize that some of the things that we feel are absolutely normal and par for the course may not be for others. But our view and my own personal view is GDPR is a risk-based legislation. I think what we're talking about here today is that in the absence of either clarity with regards to guidance from the ICO or case law, we are operating in a lot of cases in a bit of a gray area where we have to make that risk-based choice ourselves. And obviously that's quite an uncomfortable place if you potentially might find yourself on the wrong side of that risk-based judgment. So I think anything that we can do to alleviate any vagueness or any areas of dysfunction within the legislation, I think is very welcome. But at the same time, I think we also just have to recognize that, in my view, this isn't a pendulum swing. You don't drive innovation and capability by watering down legislation where actually that legislation is positioned correctly. So I think we have multiple challenges here. We have to look at the opportunities, but at the same time not lose any of the bits of the GDPR that actually are positioned in my view correctly.
Can I just sort of take away from that and then throw this out to Julia and then Alexis? So if you're saying that GDPR is and always has been risk-based, and that at times is a challenge for businesses to understand which side of the line you're going to be on, personally, it seems rather odd to me that the reforms are starting to undo a record of processing activities, starting to undo some of the necessity for DPIA, suggesting doing away with the one person that ought to guide the business as to what to do, which is the DPO. So if we're going away from the sort of strict bureaucratic, what are we going to replace it with, Julia?
Well, I guess if you take what it says at face value, then I think a lot of what's in the proposals makes a great deal of sense. And I guess what we're talking about in a lot of instances is an activity that's mandated versus an activity that someone has chosen to do. Now, I'd like to think that most businesses can be trusted to think about what activities they need to do anyway without someone telling them to do it. Mm-hmm. So if you need to do a risk assessment, you need to do a risk assessment. And in actual fact, in lots of corporate organizations, you will have, the board and the governance group and the risk register and all sorts of other pieces of material which will lead you to taking a balanced view towards how you do your data protection. So my view is, on balance, I think a lot of the suggestions make a lot of sense. Some of them take away or seek to take away more onerous administration, so trying to deter some vexatious DSARs, trying to reduce the huge volume of breach reports. I can't remember the exact statistic, but the ICO were inundated with breach reports. So I think taking a more proportionate view there would make sense. But I think we have to believe that organisations have sufficient sense to be able to figure out whether they need to do these risk assessments themselves.
Okay, Alexis, what's your view?
Yeah, I mean, I think the initial poll of not sure, reflects quite a lot of the discussion that we've been having already. I think there's obviously lots to be thinking about, and at the moment, we have to remember that it's out there for consultation. There is a lot that has been put out for consultation. I guess we will see how much ends up sticking and what everybody's responses are. I know that there are a lot of groups and individuals and firms that have been, putting together their thoughts and submitting their responses. The ICO has obviously also put out their response, which I think is worth reading. And I think from their perspective, just to echo some of the things that Julia was saying, I think, they recognize that there is room for maneuver, room for more flexibility. But coming back to your point, Robert, that there still has to be clarity and an underpinning in law, which is obviously the issue at hand across each of these different topic areas of removal of DPO appointment, DPIAs, etc. I think also it's an interesting time and an interesting context to look at it, from the perspective of the UK specifically, just because of its rich history of having data protection law, and obviously moving from its Data Protection Act and implementation of the directive, and obviously undertaking the GDPR. I mean, this PMP, Privacy Management Program approach, we've seen it, and the government also takes inspiration from other countries like Canada and Singapore, where it has been successful, and it has worked out. And it's an interesting dynamic, I think, for a jurisdiction that maybe has been subject to EU data protection law to look at things in a little bit of a different light, an international context. So it definitely is one that I think not everything will stick, and I'm seeing like a whole bunch of comments coming through from the audience about some of the things that are worrying. But I think also, just longer term as well, for some of the areas that are called out by the government of trying to ease the burden for, let's say, SMEs, for example, for some of those requirements of, ROPAs and things like that. I mean, the commission itself, I remember last year when it did its 2-year review of the GDPR, the commission itself also recognized that SMEs may need to be afforded a different approach under the GDPR, and that at some point in time, who knows when a big review of the GDPR would come around. 2 years in, I don't think the commission was too ready to do a full review of it, considering some things weren't totally up and running. But it did recognize that it might look at possible future amendments to certain provisions, in particular things like records of processing by SMEs that might not be processing personal data as their core business model, and maybe things like Yasmeen was mentioning as well, around the fact that it's a regulation, but in fact we agreed on however many 60, 70, 80 derogations that could be implemented in each member state. And so really we still have fragmentation still to work through. So Anyway, I'm going off on a little bit of a one, Robert.
No. I was going to say, while you've been talking, there's been a couple of themes coming in terms of the comments and the questions. And the one is there's a lot of people who've got a genuine concern that if we're moving away from consent to other lawful grounds and more data sharing, people are expressing a concern that Julia was saying we have to assume good businesses will do good things, but then unfortunately the bad businesses will still do even badder things if they're not likely to be fined as much, if they don't have to do mandatory DPIAs. And I'm wondering, Yasmeen, do you think there's a risk that we could lose our adequacy if we start diverting too much? And where on earth does that leave you as an international business trying to juggle completely different regime in the UK while the rest of the EU is doing the same thing?
No, I certainly agree. I think the UK data reform seems like a really good opportunity for us. But on the other hand, I think that if that divergence is too great and we're having to deal with that, I think that's going to be a real practical challenge, because many of our platforms are operating on a global basis. So for us to design a platform that is, compliant to a UK standard, to a different European standard, is a huge amount of cost and effort for us. And also, I would say from a customer perspective, trying to give people a different experience on privacy, I'm not really in favor of that just because we're separated by a body of water. Because at the end of the day, Europe has a long history around data protection. So I really do feel we need to be careful about how we approach these reforms, because as a business, we actually have to operationalize a lot of these as well. And so the greater the divergence becomes, the more challenging it becomes for us as an international business to implement as well. So.
Okay, and I'm gonna move on. I just from all of the comments coming in, I think there's a lot of concern from the delegates today that we can't be too radical. And then we get to, and it could take ages before we see where on earth this sort of settles down. But then we've also been waiting ages, Julia, to understand what on earth's going to happen with PECA. I mean, where do you think, because you're right in the middle of this with marketing and so on, what is the future of PECA is one of the questions that we've got.
Well, so PECA needs to be updated, whatever happens. I can't remember exactly when it was published, but actually it says nothing about messaging apps. It says nothing about lots of new digital technologies that we have. So it just feels terribly out of date. So whether it is from ePrivacy or whether it is from the UK government's own version, we definitely need an update. What's slightly ironic is that the EU seem to be very close to laying their egg with the ePrivacy regulations. So it would be sad if we then decided not to go with it. What's also useful about the ePrivacy regulation is that they have some parts around cookies in particular, which were highlighted in the UK government reforms, particularly around analytics and how you set your cookies in browsers, which would just get addressed by the ePrivacy. Certainly superficially, that's my view, is it would just get addressed. However, having said all of that, my fear is that it becomes a bit of a political choice and that we won't do ePrivacy just because it's ePrivacy and we want to do our own version. I feel that would be a bit of an error, because actually we've been on the ePrivacy road for so long now and the draft as it stands doesn't look so bad. So I would say we should go with it, but I think it will become a political decision.
Okay. Roland, any thoughts?
I think when taking a step back, when you're looking at the broader proposals that the government's put forward, I think what they're basically saying is they're looking at ways to alleviate what they believe is a tick boxing exercise, and certain of the proposals will definitely assist in that. I think the challenge when you go into a digital space is that, to Yasmeen's point, borders become irrelevant, and just because you have a domain name that's .co.uk versus .com or wherever else, does not mean that you should have a significant different customer experience. And if Europe are able to address some of the pain points that we have in how we've all implemented cookie compliance with the best knowledge that we have of what meets compliance today, then it just wouldn't make sense, especially for some of the large organizations that operate within UK PLC, that we would then have to deviate from that. So my view is I would be more interested to see the UK take a thought leadership approach as to how best to do this, and try and set that forward alongside any new PECA regulations that come. But at a minimum, they should be looking to take best practice from whatever our EU colleagues come up with.
Okay. Anybody, any of Yasmeen, Alexis, anything you want to add to that before we move on?
No, not really from my side. I think, I agree with Roland and Julia, isn't it? It's one to watch. Obviously, from a European perspective, it is something that is taking a lot of time. I think that's maybe one of the things that might trigger potentially the UK to move ahead. It has taken probably, I think it's now the longest piece of legislation that's been before the EU. So we're getting closer, but I don't know, Robert, maybe you know something a little bit more on some expected timeframes, but there was the time when it was going to come into effect at the same time as GDPR, but that aside. So I think that would be my only comment, is obviously let's see how long the EU ePriv takes, because I think there is a huge conversation around ePriv globally, not just within the UK and within Europe at the moment, and so that might push forward legislative reform here in the UK.
Thank you. I'm going to turn now to international transfers, and I know, Yasmeen, that you're in the thick of this and have been for some while in trying to unravel what you should be doing and when you should be doing it. Can you give us a feel as to how you've been prioritizing, transfer assessments and moving to module 1 or module 2 or module 3 in your business? Can you just give us a feel for where you're at in this, please?
No, absolutely. Again, as an international business, we move a lot of data around. There's no doubt about it, whether it's between us and our customers, between us and our legal entities, and between us and our vendors. And actually, to be fair, that's kind of probably how I tend to kind of look at it as well. We've probably been keeping an eye on this for well over a year as Schrems came along. And I think one of the things that we did a few years ago was actually bring in OneTrust, actually. And so we've got a reasonable handle on our data transfers, I'd say. And so what we've been doing is trying to keep an eye and keep abreast of the changes and make small incremental changes. So, for example, we were always, and I recently did a training session with our colleagues, we always did transfer impact assessments, actually, because whenever we brought on a new vendor, we assessed where that vendor was. We assessed what those transfer issues could be. We were always looking at all of these issues. The difference has been, obviously, with the guidance that's come out from Europe and then from the UK, they're a little bit more specific about some of the questions we should ask and what we should look for. So for us, it's kind of been evolving our process in essence, and being a bit more specific and looking at those risks more specifically as we've received that guidance. So so we've changed our process, changed our vendor process to examine those risks more carefully. In the more recent times, as the new contract proposals have come through, the new SEC template, yeah, that's been pretty challenging, to be honest. That divergence between Europe and UK is not easy to try to get your head around. So, you know, again, we've kind of been moving sort of cautiously and slowly, looking at the UK, looking at Europe and their templates first, and then when the UK versions were issued, the IDTAs and the UK addendum in the summer. And so now, as we're starting to repaper our vendors as such, or actually, sorry, we're not repapering our vendors. What we're actually doing is we're taking a basis of where contracts are being renewed or new contracts. So we can't use the old SCCs, basically. There, we're starting to use the new templates. And so that's also allowing us to get used to how to use the new templates, I would say, as well, and how suppliers are also applying them. So you know, it's for us, we're sort of on that learning curve. And then what we're hoping is the UK consultation should complete. I think the data is complete now. If we get those final versions from the UK Commission by the end of this year, hopefully, then we can also take a position on the UK transfer. Because as right now, we are using the old SECs for UK to Europe transfers. So it is a bit cumbersome right now with some of our new contracts. We're using the new SECs plus the old SECs. So honestly, yes, we are putting in data transfer sections that are probably 40 to 50 pages long. So we are hoping, though, once the UK position is finalised, we'll be able to take advantage of the UK addendum that was proposed and then streamline the whole sort of agreement again. Okay.
And I guess you're still taking a commercial risk-based approach as well as you do this.
Yes, absolutely.
Yeah.
Absolutely.
Yeah. And how about you, Roland?
Yeah, so I think, similarly to what Yasmeen said there, we're doing a bit of a data fact gathering exercise at the moment, because we've historically relied on SCCs, even when we didn't necessarily need to rely on SCCs. Obviously, you know, we have adequacy with Europe, but we're still taking that risk-based approach to say, you know what, let's underpin it. Let's have a standard approach. I think the view that I'm taking is that I still believe there are elements in what both the EU and also in the UK's proposals under the IDTA, this idea that data controllers will perform those assessments, those country-based assessments on a country-by-country basis. I still strongly believe that will create a lot of divergence in how people approach those risk assessments. It'll, you know, back to what the government and what the DCMS is trying to do with these proposals around how do we make something less burdensome. I would argue that is an increase in burden. So the UK just went through quite an intensive exercise to get adequacy. So we know that, and the UK themselves are talking about a number of partnerships and adequacy decisions that they are making now that obviously they're outside of the EU. So we know both the EU and the UK government have the capability to perform adequacy-based assessments at a country-based level. So I guess what I'm strongly pushing back through these consultations on, and have been, and will keep saying it to anyone who listen, is that actually my view is that this should be centralized. We as organizations should be able to rely on countries that have already been assessed for their overall adequacy. And that we can then take that into we still, as data controllers, are accountable for the risk of processing with a third party in that country, in that third country, but we will do so in a consistent manner, having that done by an independent body rather than that being done by individuals, because otherwise I think we're just creating a bit of a cottage industry we will probably need, I'm sure, various legal firms. Sorry, Robert, will love the fact that organizations and various consultancies are looking for this assistance. But yeah, that's one of the areas as an organization that we are obviously preparing ourselves, and we are performing in our European business already, where we're putting new contracts in place under the new EU SECs and performing the country-based assessments. But yes, it's an onerous task, and we're still looking for opportunities to streamline that.
Thank you. And I was just going to get comments from Alexis on. So what I'm finding with a lot of my clients, who are generally US headquartered multinationals operating in every continent, that the complication is that just within an intra-group controller to controller, you've got the variations in the UK, you've got the new SCCs, and then you've got the ASEAN model clauses. You've got to think about the same restrictions on transfers from Abu Dhabi and the UAE. I mean, isn't it just easier to do BCR?
Oh, interesting. I wasn't expecting that as the conclusion.
No, I'm sorry to throw that one, but I'm just interested.
No.
You're dealing with so many multinationals. You must be seeing them having this same dilemma, that it's not just all about the EU and the UK now.
Oh, absolutely. No, I totally agree. And so many different things. And, just to echo Yasmeen and Roland, I mean, it's a huge task. And the thing that I hear most from customers is that it really is, it's a project management task. I mean, yes, there's a lot of like privacy and, vendor management and all of these good things, but ultimately it's a huge project management task. And I mean, this is for some of the larger organizations that are able to do this. I have heard stories where they've appointed point people to manage the whole process and to act as a PM to help coordinate all of the different functions internally, whether it's legal, it's IT, whether it's whomever, just so that they can continue to focus on what's needed from the privacy function, rather than also being the person that's going around collecting everything from everybody else. Of course, not everybody can do that, but BCR is an interesting one. Obviously, it was such a mechanism enshrined under the GDPR. It was going to be the mechanism that could pave the way for a lot of international data transfers, obviously, for these intergroup situations. And it still seems to be that it's a process. Obviously, it's a big process for an organization to undertake. And it's something that, just given the fluctuating landscape of international data transfers that has been since, I mean, we can take it back to 2013, from the beginnings of the safe harbor framework and judgment there from Schrems 1. There's been so much fluctuation for organizations to deal with that after safe harbor, it's like, okay, well, let's put in place SCCs, and we've always got that as like our backup mechanism that we can rely on. And okay, if we want to overlay that with Privacy Shield or Apex CBDRs or whatever the case may be, we can do that. But we've got SCCs, and then obviously we have the Schrems 2 judgment and all the work, and then the update to SCCs as well. And the interesting thing is that we haven't really even unpacked yet is that obviously the CJU judgment, and from the EDPB's guidance as well, it applies to other mechanisms like BCRs. And so it's an interesting one to see how that will develop for organizations that are going down a BCR process at the moment. And having to have a look at the same issues that organizations are having a look at from their TIAs at the moment.
Yeah. Sorry, can I just jump in there? Because you've mentioned the word TIA, and I want to move on from international in a minute, but there's a really interesting question come in, and I'm going to, what do the panel think about the question of how a TIA should be used with third parties, where the GDPR applies to the third party on the Article 3.2 extraterritoriality? Have you come across this, Yasmeen, where your other party is not in the EU but are caught by the EU by the nature of the services they're offering? It's a hell of a question, this one, I must say.
Do you want to try answering it, Robert?
Oh, thanks. Thank you. I mean, it is an interesting one that, again, with just looking at the SCCs, you've got this problem that there are an awful lot of organizations that are caught by them, even though on the face of it, they're not in the EU. But they are exporting because they're in the US, but they're caught by the extraterritoriality. And then you have to say, well, why would you need to do an international data transfer if they're already having to live up to a particular level? But I don't think you can avoid the TIA. The whole point of the guidance was that you need to have made that assessment. But what I did want to ask you very quickly, Yasmeen, is, are you finding, or are you expecting the other party, the importer, to be working hard with you to help you jointly complete that assessment? You're on mute.
Yasmeen.
Sorry.
Right, back on. That's exactly what we found in reality. So the vendors that we have been onboarding in the last month, to be honest, we've had a couple of new big contracts coming through. And when we've actually actively engaged on the discussion about the data transfer, the SCCs, what questions and so forth, they've been actually very actively involved. Often they've got their own sort of transfer FAQs prepared for us. They've got templates ready for us. So I actually think vendors or some suppliers definitely understand that if they're going to do business with European-based companies, it's actually better for them to be ready with their own proposals. So to be fair, we're seeing a lot of that. Quite positive engagement, and for us then that's really helpful, because in essence that gives us an easy springboard for us to go from there. Okay,
I'm going to move on, and I'm going to pass this to Julia, and Julia is not going to ask me to answer it. One of the questions we had in was, how often should a privacy policy be updated, and do you have to communicate that to all clients?
Oh, it's such a good question. And I think it depends is always the answer.
No, that's not good enough.
So I was thinking about this, and I thought, well, when would you make a change? Obviously, if there's been an acquisition, or if there's some kind of M&A activity, and you're transferring from one place to the other, then you're going to have to let people know. So that's one part of it. And then you start thinking about, there's new teams or new processing or new marketing, anything that has a kind of material effect, I guess. And then I started thinking about, well, what would that be? So if you were to start doing some significant profiling, you might decide to do it. If there's a very different way in which you're doing marketing, you might decide to do that. But I think in the end, you sort of risk assess each of these activities. So you may change your privacy policy. So, for instance, if, say, I start to do Facebook lookalikes or custom audiences, not done it in the past, then obviously you'd want to change your privacy notice. And then I think you have a debate about whether you actually communicate with your customers or not, and what you're going to say to them. So I think keep the privacy policy up to date, absolutely keep that under review the whole time. make those changes on a regular basis. And then I think anything that is material is communicated to your consumers as well. I've had situations as well where, you get to, you change the way in which you retain data. Then I think that is something that potentially you communicate as well. And you may offer people the options to either opt in or opt out based on how long they've been involved with you.
Okay. Yeah. Sorry, Yasmeen. Yes.
Yeah, I can probably share a little bit there as well. We have like a global privacy policy that sits over many of our brands. So for us, we're quite keen to make sure it kind of represents what we do. And yes, we do actually revise it and look at it quite regularly. And our privacy team, if they feel that something significant has changed, will introduce it. So, for example, one was last year when COVID happened, we couldn't run on-site events. So we suddenly went all online to digital events, for example, and virtual events. And therefore, we did know that we would be collecting significantly more data about people. So we updated our privacy notices when people registered and signed up to be more explicit about that. So soon as they registered, and then we also updated our privacy policy, because for me, the privacy policy is kind of the backstop for us as well. And so I think it is important to keep on top of it, not just to it to be a dormant sort of, we've done it once, you don't shake it off. And I also think, and I could be wrong on this, when I was looking at CCPA and it came in, there was something in there about a mandatory annual review as well. So I'm not sure if it was finally, became part of the legislation in California. But again, I think keeping it up to date is incredibly important. In terms of positive communication of the changes, I agree with you, Julia. It's kind of thinking about what are the when you're introducing those changes, are they significant enough that we feel that a communication to individuals is actually necessary? So it's a kind of a case-by-case basis at that point.
Well, and how do you view that, Roland? I mean,
yeah, so I think we take a view of so that old chestnut of reasonable expectations, and actually, if you read the government's data proposals, the word reasonable comes up quite a lot. So reasonable data processing, and it's back to this risk-based approach. So especially if you have a business where you have a lot of loyal customers that you would have onboarded maybe years ago when your privacy notice looked quite different because your business looked quite different. So your new customers that you're onboarding, or in our case, we have lots of different types. We have customers, we have advisors, we have trustees. So what we do is, if there's a material change, to Julia's point, then I think even just looking at the GDPR, a material change is already mandated as something that you then need to go back out to meet your transparency obligations anyway. But actually, what do you do in that gray bit in between where you've changed it, you've added some process, you've clarified certain things, maybe you've made it better, easier to read, more plain English. Actually, I think that your view should be actually if a customer was asked, did you reasonably expect us to use your data in that way? And would you have understood that? If your answer was, well, probably in the historical one, no, you probably, too much legalese, you wouldn't have understood it. Then actually, again, in the spirit of the legislation, you might not be obligated, but actually maybe you should, because at the end of the day, with customers at the heart of our businesses, we operate on trust. That's why they allow us to use their data. It's their data, and if they wouldn't reasonably expect their data to be used that way, then updating them about the new privacy notice is an ability for you to address that problem. So I think that's the way we look at it. If it's material, we know we need to do it. There's no question about it. But if it's kind of in between, then we ask that reasonable expectations question.
Yeah, it's interesting. There's another comment come in, which is all around trust. That going back to where we started with the proposed reforms in the UK, where you're seeing the DCMS suggesting that we can have more reliance on legitimate interest, and for certain types of processing, we don't need consent even where it's sensitive because it is for the greater good, etc. that, this person has said, aren't we heading towards a time when individuals will lose trust because they've really no idea what you're doing? Because it would appear you can start doing sharing or using the data for purposes for which it's a new purpose and not one that you had the original intention for. And going back, I think, to your point, Roland, almost every time you do an assessment or you update your ROPA, you're almost forced, or should be, going back to the privacy notice and reflecting the same changes there. It's sort of almost 360 if you're going to be a compliant organization. I wanted to move on, and I'm watching the time and we're at the hour, but I'm intrigued with one question we've had, which is, what is the panel's view of the Irish DPC recent fine of WhatsApp? Was it proportionate? Julia, what do you think?
Yes, I do. I did some research earlier and discovered Facebook's turnover in 2020 was £86 billion, and their profits were dollars. Profits were $29 billion. So £193 million in that context is literally a drop in the ocean. And I think the only way you will get Facebook to pay attention to any of these issues is if the fine is huge. Now, of course, Facebook don't like it, and they're going to be lawyered up and will probably argue the toss for a very long time indeed. But my view is that it's about time we called them to account. I think they've basically done whatever they've liked for far too long.
Okay. Alexis?
Yeah, I mean, it's an interesting one. I think obviously enforcement has been the talking point of the GDPR for a long time, for ever since the Commission put forward its draft on the table. It's been the biggest talking point, and there's been a lot of expectation around fines and numbers and things like that. And there have been other large fines that have been issued. Obviously, this is a pretty hefty fine. The one thing that I find interesting as well is the mechanics of the decision itself. This kind of brings to light a few of the things that DPAs themselves have been talking about, which is in relation to the one-stop shop and the consistency mechanism, and making sure that there is a harmonized approach to enforcement. And so I think, whatever the number would have been, whether it's, proportionate or not, I think it's interesting to see where future enforcement also goes, bearing in mind this one-stop shop mechanism and the consistency approach that was supposed to be one of the benefits of the GDPR. So yeah, I mean, I know that there's a couple of other things that are going through. Well, I mean, there's from the sounds of it, there's quite a few cases that are still pending between the EDPB and various national DPAs. But I think it'll be interesting to continue to see how things unfold, because national DPAs have been active. I mean, Spain issues fines every day. The AEPD, not 200 million euros, but they issue fines all the time. And other DPAs, Italy is another example. There are lots out there that are super active, but also fines are, just one of the mechanisms. And there are, other things that we've seen, particularly in light of Schrems 2, where other enforcement actions could be even of a bigger repercussion than a monetary penalty. A cessation of processing activities or a cessation of transfers from one country to another. So I think enforcement is definitely under the microscope at the moment in the EU. I think we will see more to come over the next 12 months.
Okay. Roland, do you want to add anything to that?
I think the only thing I would add is as as Alexis there said, I think the DPC started with a fine around 50 million euros, and obviously that was then challenged by some of the data protection authorities in Europe, and it'll be interesting to see what that does. Obviously we have lots of big technology firms in Ireland. Ireland has DPC have been in the crosshairs by a number of privacy organizations for not having shown enough teeth. Obviously now they've been kind of mandated. We also need to recognize that it's not just a fine. They've given WhatsApp 3 months to get their house in order. Or otherwise face potential, further penalties. I think it's a bit of an interesting watching brief for those of us that have international and European based processing, but also to reflect how is that going to, obviously the ICO took a very different view with Marriott and British Airways because we were in a COVID situation. I guess the challenge now becomes if we find ourselves in a situation where we have a breach of compliance in the UK, for us to show that we are a trusted and safe place to be processing data. I think this has set the bar as to what a fine looks like, and potentially may have. I mean, we'll need to see what continues, but this may be a kind of a window of what to come. But yeah, I mean, the fines, to Julia's point, are less than 1%. So yeah, there's still a lot, much more that could have come out of this.
So very quickly, there's a question come in about Facebook's legal basis for processing, where they're suggesting it's contractual necessity for behavioral advertising. And when you look at part of the WhatsApp fine, one of the issues that was raised was that WhatsApp, amongst other things, were relying upon legal obligation for some of the processing. And the result was, well, you didn't say what the legal obligation was. Do you think we're being forced, Julia, into a requirement to have actually longer privacy notices than we used to, because we have to now be specific about every legitimate interest, every legal obligation, etc.? Are we actually going the wrong way now? Nothing will be plain and intelligible.
Yes, potentially, yes. I mean, I've done quite a lot of work on ad tech and advertising, and I worked at The Guardian when we were working through an awful lot of our thinking around DMPs and managing customer data. And the problem you've got is there's inherent tension in one side trying to explain what you're doing versus trying to explain something that is at its heart very complex, and then a requirement to be completely open and transparent. And it kind of speaks to the fact that generally we've failed to explain to consumers in an engaging and dynamic way what data protection is about. I've always struck me that this explaining how data is used is almost a marketing branding challenge around building trust with your customers and giving them a sort of clear pathway to explain at a high level what this is all about, and then moving into the detail. You obviously need the details somewhere, but that should not just be the only way in which you communicate with customers, because most people won't bother to read the documents. That's the truth of the matter. If you look at all the information around the cookies and complaining about cookies, everyone goes, it's a barrage of cookies, I'm not interested, I'm just going to press the button. So, building interesting, creative ways of talking to consumers through video or, visually more interesting materials feels to me like something we should work on in addition to the, by necessity, longer privacy notices.
Okay. I'm conscious now we're just nearly up to 10 past the hour, and I can see people are quite rightly logging off. So I think if I can say to the audience, on behalf of us as your panel, thank you very much for putting up with us for the last hour and a bit. We did actually cover, I would say, about 85% of the questions that we had, and apologies to anybody who didn't get the precise answer you were looking for, as it's quite clear. I don't think anybody can say, you know, I have all the answers. We are still learning on the hoof, as they say. I'm going to pass back to Julia now, just to close this. Thank you, Julia.
Okay, so first of all, can I thank our audience for joining us today? It's great to have so many comments in the chat, and we had many questions in advance, so thank you very much. We really appreciate that. Thank you, Robert, for being the Master of Ceremonies, brilliant as ever. And also thank you to Alexis and Yasmeen and Roland for being wonderful panelists. We really appreciate it. And finally, thank you to OneTrust for sponsoring this event. They've been good friends as always. So thank you very much and goodbye.
Thanks, everyone.
Bye.
Bye.